Hi everyone. Today's unit that we'll be doing is Industrial and Intellectual Property Law. My name is Shazia Khan. Just a little bit of background to the unit, and then we'll go straight into Learning Outcome 1. So the unit reference number is L6187918, and that needs to be put on when you do your assignment. The unit title is Industrial and Intellectual Property. It's a level 7 unit. Number of credits to 20, and it's a mandatory unit. And the grading in this is pass or fail. The aim of the unit is to enable learners to gain an understanding of regulatory and legislative requirements relating to industrial and intellectual property laws. Things like, patents, copyrights, trademarks, trade secrets. Learners will examine relevant issues, including financial strategy, debt, and equity management, the drivers of shareholder value, and corporate governance and asset portfolio management. So I'm going to just quickly go through the learning outcomes, and then we're going to start on learning outcome 1. So learning outcome 1 is to understand the underlying rules related to intellectual property laws. We'll be looking at the assessment criteria, which is to analyse the term intellectual property 1.1, 1.2 to explain subject matters of intellectual property rights, 1.3 to evaluate types of property and associated laws, 1.4 to critically analyse the impacts of intellectual property on public interest, 1.5 to analyse issues relating to the breach of confidentiality information in intellectual property. And the indicative content for learning outcome 1 is intellectual property, creative work, which can be treated as an asset or physical property, types of intellectual property laws, associated impacts of intellectual property law on public interest, issues relating to any sort of issues in breaching any sort of confidential information. Then learning outcome 2, there are 4 learning outcomes and then an assignment discussion. Learning outcome 2 is to understand the associated laws and procedures relating to copyright and trademark laws and the impact of jurisprudence of EU intellectual property law on the UK. We're going to look at 2.1, which we're going to look at analysing the underlying principles of copyright. 2.2 to evaluate trademark and its various elements to protect words and symbols. 2.3 to compare and contrast the forms of copyright laws in the UK and internationally. 2.4 to analyse the framework of trademark laws as operated in the UK, Europe and internationally. And 2.5 to evaluate limits, enforcement and infringement of copyright and trademark. The indicative content for learning outcome 2 is trademark definition and the frameworks in the UK and internationally. Limits, enforcement and infringement, copyright and trademark law, treaty and community trademark system, application for protection, EU approach to intellectual property law, and cases that have impacted upon the UK and the future relationship between EU and UK intellectual copyright law. Then we move on to learning outcome 3, which is to understand the different forms of industrial property rights. Look at 3.1, which is to critically analyse the justifications of intellectual property. 3.2 to analyse law of industrial designs, and 3.3 to compare and contrast the UK law national registered design right and unregistered design right system. The indicative content for learning outcome 3 is to look at patents in utility models for inventions, industrial designs, trademarks, geographical indications, patent scope, rights, types, registration, applicable laws, registered against unregistered system. The final learning outcome is learning outcome 4, which is to understand the remedies available for breach of intellectual property. We'll be looking at 4.1, which will evaluate the application of sanctions for the misuse of intellectual property, including civil and criminal remedies. 4.2 to evaluate legal administrative mode to apply for or to deal with infringement of industrial property rights. Indicative content for learning outcome 4 is to look at sanctions of breach, the misuse of property, what remedies are available for individuals, timeline and stages of patent prosecution, and remedies in international contexts. Then we'll have another session, which is the assignment discussion session, which will provide the learners of evidence to demonstrate that they have fulfilled all the learning outcomes and completed the assessment criteria to pass the unit. So, as it says, it's a portfolio of evidence, and the assignment will be learning outcome 1 to 4, and it's 4,000 words. So now we'll go on. So this assessment criteria, unit specification is available on Moodle for you to have a look at as well. So now we'll go on to learning outcome 1. With you. So learning outcome 1 is to understand the underlying rules relating to intellectual property laws. Now, as the world becomes more connected and globalized, there's, a big increase in different type of innovation and new ideas. And there's more demand for protection of these ideas. So if someone who has come up with a new invention, for example, inventing something to do with any sort of invention, it's so important that the individual understands intellectual property rights to ensure that there's any sort of protection for that individual, because it's so important for them to be protected against their invention, to protect it, because, it may be that someone may steal that invention. So the unit aim for learning outcome 1 is to enable learners to gain an understanding of regulatory and legislative requirements relating to industrial and intellectual property laws. Learners will examine relevant issues, financial strategy, debt and equity management, and the key drivers of shareholder governance and asset portfolio. The indicative content for learning outcome 1 is intellectual property, creative work which can be treated as an asset or physical property. Types of intellectual property, and we'll go through them in more detail, and impacts of intellectual property on public interest, and issues relating if there was a breach of any sort of information. Key terminology, so intellectual property relates to the establishment and protection of intellectual creations, such as inventions, as we mentioned, designs, brands, artwork, and music. And these are rights established, protected, and enforced through patents, trademarks, copyright, trade secrets, and designs. So it's really important for you to look at protecting your invention or your right in regards to anyone else trying to steal that. Like, for example, another example to use is Coca-Cola. Its trade secret is protected. It has to be, because, it's so important out there, and it's such a popular a brand. So introduction to intellectual property. So as we said, intellectual property refers to some sort of creation of the minds, such as inventions, literary or artistic works of symbols used to represent a brand or product. So it's really important, that we take into consideration what intellectual property is and why it's there. So it's there to protect individuals' rights, so your own rights as an individual. And, it is in the UK, we have the Intellectual Property Office, IPO, which is a government body responsible for any sort of intellectual property rights. So, it deals with the main 4 categories: copyrights, patents, trademarks, and both registered and unregistered designs. So, it's there for protection of that kind of right. It is there to protect individuals from any sort of issues that may occur. And, intellectual property is, it protects new inventions, like we said, and how it covers the work, what they do. It is there for the full protection of the individual's rights. So we've got a video here that you can watch in your own time, and it is on understanding intellectual property. So it looks at what are intellectual properties. It looks at why are intellectual property rights so important. It looks at challenges with intellectual property rights, and it looks at best practices for promoting intellectual property rights. So why it's so important, why is the need to protect it, the key principles, who's the owner of it. These are things that need to be looked at when protecting intellectual rights. So the main principle in regards to intellectual property is that the creator who has created the intellectual property is considered to be the owner of it. And the effect of this principle can be significant unless the commissioner and the creator of a work or invention agreed otherwise in writing. The author or inventor can prohibit all use. So, it's the main person who deals with it is the creator, who is the one that's the individual that has created that invention or any sort of works or anything. So types of intellectual property. Intellectual property can be categorized in four main types: patents, trademarks, copyrights, and trade secrets. Patents protect new inventions, giving the patent holder exclusive rights to use to commercialize the invention for a specified period. Trademarks protect brand names like slogans and logos used on goods and services, things like Coca-Cola. It'll be things like Costa, slogans and brand names. Nike could be protected in one of them. Copyrights protect works of author, so literature, music, ensuring that they can control the use of their distribution. And trade secrets protect business information that provides a competitive edge. So what we're gonna do now is go in detail in regards to each one, so you've got more of an idea as well. So first one to go through is patents. So patents is a valuable form of intellectual property. So, it's really important that if you have a patent and someone uses it without your permission, you have the right to claim for compensation. So, it's really important that you take into account looking at patents, that you have that right to claim for any form of compensation. Applying for a patent can be complicated, and some products need to be protected by a number of different patents. A patent agent can help present your application and make sure you are not infringing someone else's intellectual property rights. You may be able to use someone else's patent with permission. So, you have permission. If you have permission, you're able to use someone else's patents. But it's important that, you know that if anything happens or, someone else uses it, you can get a form of compensation for that, because it is regarded as one of the important things in regards to trying to get it. So it could be an invention. Patents protect inventions that are new, useful, and offer a significant improvement already over the one that exists. So like it says, there's three main types: utility patents, which cover the useful processes, machines, plant patents, and patents in regards to that protect a variety of plants. Like we said, it must be that the invention must be able to be protected, or form of work, and that if it is breached, you can, secure patent protection for a product process of the length. The length of a patent protection lasts up to at least 20 years. Normally, a patent gives you the right to stop others from copying, manufacturing, selling, or importing your invention without your permission. So it's one of the main ones and the most important one. The next one is trademarks, and again, that's a really important aspect of it. In regards to, so trademarks is a symbol, word, or words registered, established by the use of representing a company or a product. So it's really important in regards to trying to identify what a trademark is, because it's really important in regards to, it could be any words, it could be any phrases, it could be any symbols, designs, or combination of these. And it identifies your goods or services and how customers recognize you in the marketplace and distinguish you from other competitors. The word trademark can refer to both trademarks and service marks. And a good example of a trademark is the registered is the company Nike, who have registered this trademark in special format, combining Nike with the swoosh logo. And McDonald's is another example as well, quite a popular example of that in regards to, the fact that people, use that as an example. Another registered example, which is quite popular, is Ford. Some of the ones, Domino's, Coca-Cola, is a trademark. And it's a special format with the lettering and the styling of that letter. So it's really important in regards to that. And, you have different formats, like we said, Nike. And another one is the Head and Shoulders logo, which is by Procter & Gamble company. Trademarks, these are rules on what can and cannot be registered as a trademark. Trademarks are highly valuable and can be a major influence on the marketing and recognition in the marketplace, like we said, Coca-Cola, things like that. The main purpose of a trademark is to identify the source of the product and to distinguish that product from products that come from other sources. An example we could use again would be to help you choose between a Coke and a Pepsi. So the marks can also be used to identify and distinguish a service. So it's really important that you look at that. Three most common trademarks are names, logos, and phrases, and the most popular trademarks. They represent the brand. Every successful brand is built on at least one trademark. And again, going back to it, the most popular one to look at is Coca-Cola, which is a really good trademark to use. Trademark is important step for protecting the brand identity. So lots of organizations and businesses use it. It would stop competitors from poaching your customers by intimidating your brand. It can also offer some protection if those copycats do something that will damage your reputation. So there's a form of protection there for you, and it will help you in regards to identifying and protecting you. So, it's really important in regards to trademarks. The next one we're going to look at is copyrights. So copyrights, again, is another part of intellectual property. When you create a literary or dramatic, musical or artistic piece of work, you will be granted copyright automatically. So if someone you employ creates this for you during their normal course of employment, you will own the copyright. However, the person you employ will own the copyright if an agreement has been signed that states this. So copyrights covers works such as company documentation, software, songs. It could be a piece of work. You will be granted copyright automatically. It could be original, paintings, drawings, or photographs. Copyright also protects sounds, recordings, and films. So it's quite wide, is copyright. So it is where the creator of any sort of original work or another right holder has the exclusive and legally secured right to copy, distribute the actual copyright. So it could be things like, audiovisual works such as TV shows, movies, online videos. So these are some examples of copyright. It states here that copyright is the legal right that grants the creator, as we mentioned. Copyright protection covers a wide range of works, and copyrights are fundamentally in protecting the rights of creators, like we said, in ensuring that everything is done fairly. So it's really important in regards to copyright. The next one is trade secrets, another really important one in regards to trade secrets. When we look at trade secrets, it's sometimes difficult to identify from trademarks or any other sort of element. Trade secret is any practice or process of a company that is generally not known outside of the company. Information considered such, it could be a secret invention, it could be, something that they've created secretly. It could be technical information. It could be a formula, like things like, Coca-Cola's the formula to Coca-Cola, which is the example on here as well. The taste of Coca-Cola is a trade secret. And they, trade secrets involve confidential information. They take the form of, a practice or a process, such as a recipe for a food or drink, like we said, Coca-Cola, it could be anything, Costa Coffee, it could be anything in regards to try to identify this. And, like we said, most famous one, again, is Coca-Cola. The company has kept its formula a trade secret for a long time, for over 100 years. And it's locked away, and only a few people have the exact ingredients to the Coca-Cola. So could you imagine if that, if that ever, got out there and people tried to create their own Coca-Cola with that ingredients? Another one is another one that's quite popular that comes to mind is a KFC recipe. Is that a trade secret? Yeah, it is, because they have again hidden that secret as how they cook the chicken and the outside batter of the chicken. So it's quite interesting to look at different trade secrets examples. Now we're going to go on to intellectual property law enforcement and infringement, and why that's important in regards to trying to prevent any sort of civil actions or anything in regards to intellectual property. So, the infringement of intellectual property rights through, among other, counterfeit and piracy creates substantial losses to industries as it undermines companies' investment. So if there's any sort of, issues around intellectual property, it causes a big issue with the company, and also, there are protection for the individual, but it could affect the company as a whole. So enforcement of intellectual property rights is carried out through civil actions, such as lawsuits and in some cases criminal sanctions. Infringement occurs when intellectual property rights are used without authorization, like we said, without having the permission. Remedies for intellectual property infringement And committing plagiarism remedies typically include things like injunctions to stop infringing activities, monetary damages, compensation, or the destruction of infringing goods. Effective enforcement of intellectual property is important. You know, it's so important to protect your assets. It's so important, for example, another example again, Coca-Cola, to protect, you know, their ingredient, to protect their rights, you know, because these people have created this, you know, it may be an invention, it may be the recipe, so it needs protecting, you know. It's crucial for maintaining a competitive edge and maximizing the value of your creation. So, you know, you need to protect that. You need to protect your rights. And, you know, there needs to be strategies in place in regards to any sort of enforcement, any sort of infringement, and obviously implementing protection measures for intellectual properties, you know, to try to protect your properties, and any sort of legal action, you know, like we said, injunctions, it could be compensation. You need to be also collaborating with other authorities and industry bodies who can bolster your intellectual property enforcement efforts. You know, focusing on international protection as well is another one. So in conclusion to the first part of it, understanding the underlying rules relating to intellectual property laws is vital for protecting innovations and creative works. Intellectual property laws encourage innovation and creativity by granting creators exclusive rights to their inventions and works. These laws promote economic growth and protect businesses. It's all about protecting your rights as an individual. These are the references for the first part of it. Now we're going to look at 1.1, which is to analyse the term intellectual property. And as we stated earlier, intellectual property refers to the creation of the mind, inventions, literary and artistic works. And the names and images, designs is protecting the law, enabling creators to gain recognition or financial benefit from their creations. And it is a legal concept that grants creators exclusive rights to their creations, providing them protection. And it's really important to provide that protection for these individuals. Categories of intellectual property, which we looked a little bit at earlier as well: patents, trademarks, copyrights, and trade secrets. Importance of intellectual property. It plays a really important role in fostering and creating legal protection for any sort of businesses that have created any sort of products or invented any sort of products, and protects their interests. The legal framework and intellectual property protection includes international treaties such as the Berne Convention and the Paris Convention, and in UK the laws are the Intellectual Property Act and regional agreements with the European Patent Convention. And these laws are in place so that, you know, we protect and uphold any sort of rights of the creators, ensuring that they have some form of protection. So, you know, that the rights are not breached, but, you know, they're not taken away from them, so that the creator is protected. Challenges in intellectual property, because there are lots of challenges when it comes to intellectual property. And the main challenges are registry issues, backlogs, delays in trademark and patent registration, lack of experts as well, drafting, the cost, the protection, things like infringement, piracy, counterfeiting. There's lots of organizations out there that still counterfeit certain copyright trademarks, and, you know, try to, Nike would be a popular one that people try to trademark. And because of the digital age and the issue of privacy, you know, to reproduction or distribution of copyright works, there's lots of organizations still doing that. And you know, it's the plagiarizing, and that is another big issue within intellectual property rights problems: plagiarizing, the act of stealing another person's intellectual property and using it as one's own without giving any credit to the original inventor. So, you know, there are still lots of difficulties. There are still challenges, you know, with intellectual property. and there are still people out there that are trying to steal the intellectual property rights and trying to steal the inventions, counterfeit documents, and the counterfeit things. The first one that came to mind was Nike. In conclusion to 1.1 assessment criteria, intellectual property is a fundamental concept that supports innovation, creativity, and economic growth by granting creators exclusive rights to their creations. Understanding the effectively managing intellectual property is essential for individuals and businesses to protect their inventions and works. And these are the references for 1.1. Now moving on to 1.2, explain subject matters of intellectual property rights. So intellectual property rights protect the creations of the mind. These rights provide creators with exclusive control over the use of the creation. And the main categories of intellectual property is patents, trademarks, copyrights, and trade secrets. Patents, as we mentioned earlier as well, is to protect new inventions, providing the patent holder with the exclusive right to use or sell the invention for a certain period, typically 20 years. Trademarks and copyrights. So trademarks protect symbols, names, logos, and slogans used. And popular one was Nike and Coca-Cola. Copyright protect original works of authorship, including literary, musical, and artistic work, as well as software or architectural designs. Trade secrets and other intellectual property rights. So trade secrets protect confidential business information that provides a competitive edge. And in this is a formula. It could be ingredients. It could be like the Coca-Cola, how they have produced that, the ingredients on that. Other intellectual property rights, industrial designs protect the aesthetic aspects of objects, geographical indications, plant variety rights. So these are other forms of intellectual rights. In conclusion to 1.2, assessment criteria, intellectual property rights cover a broad range of subject matters, each providing specific protections to foster innovation and creativity. Understanding these rights is crucial for any sort of business and individuals to protect their intellectual property. These are the references used for 1.2. Now moving on to assessment criteria 1.3, which is to evaluate types of intellectual property and associated laws. As we said, there's lots of creations of the mind, including inventions, symbols, images, and now we're going to look at understanding the laws around it. So patents and patent laws. So we've got the legal protection for any sort of new inventions, and we identified that it was 20 years from the filing date. Patent law varies in different countries and different jurisdiction. The UK patents are governed by the Patents Act 1977, and the reasoning behind that is that they have a form of protection and the laws are in place that they need to make sure that they have protection over any sort of exclusive rights. Trademarks and trademark laws. So trademarks protect symbols, like we said. In the UK, it's governed by the Trademarks Act 1994, and that's in regards to any sort of protection for to prevent any sort of issues of trademarks. Copyright and copyright laws are protected any sort of works of literature, music, and in the UK, the copyright law is the Copyright Designs and Patents Act 1988, which again provides the creator exclusive rights to reproduce, distribute, perform, and display their works, and it provides them a form of protection if anything does happen. Trade secrets and trade secret laws protect confidential business information that provides to competitive advantage. So unlike patents or trademarks, trade secrets do not require registration but must be kept confidential through reasonable measures. And we have the trade secrets enforcement Regulations 2018 in the UK, which provides legal framework for protection of any sort of trade secrets. Other intellectual property rights and laws include things like the industrial designs, which protect visual designs of objects, governed by the Registered Designs Act 1949, which is in the UK, and geographical indications indicate products originating from a specific place governed by EU regulations. And plant variety rights protect new plant varieties governed by the Plant Varieties Act 1997 in the UK. In conclusion to the laws around each element of intellectual property, understanding the various types of intellectual property and the laws associated with them is crucial. It's really important because it needs to protect the individuals, and it also needs to protect and enforce any sort of intellectual property rights, be it on trade secrets, copyrights, and it ensures that everyone is aware of the legal frameworks, and also that businesses can safeguard any sort of innovations and creations, because these laws need to be put into place because it protects the businesses, but also safeguards the individual as well. These are references used for assessment criteria 1.3. Moving on to 1.4, critically analyse the impact of intellectual property on public interest. And the management of intellectual property has become increased interest to the public and is reflected in the increased reporting of intellectual property related to disputes, sales and decisions in UK news. So it's really important, you know, that intellectual property plays a big role within public interest as well. So intellectual property laws play a crucial role in fostering innovation and creativity by granting creators and inventors exclusive rights. However, it's essential to critically analyse how these rights impact public interest, including access to information, affordability of products, and the dissemination of knowledge. So it's really important to take into account how these affect and how they impact the public interest as well. You know, it needs to be taken into account how they affect any sort of you know, individuals. So positive impacts of intellectual property on public interest. Firstly, to encourage innovation. So intellectual property rights incentivize creators and inventors by ensuring they can benefit financially from their work, leading to more innovation and technological advancements. Number two, economic growth. So strong intellectual property laws can attract investment and promote economic development, creating jobs and boosting local economies. Number three, quality assurance. Trademarks and patents ensure the quality or authenticity of products, providing consumers with reliable and safe options. So see, these are some of the positive impacts of intellectual property on public interest. We also have negative impacts of intellectual property on public interest. Firstly, the access to medicines. So patents on pharmaceuticals can lead to high prices, limiting access to essential medicines, especially in developing countries. Number two, the knowledge of dissemination. So copyrights and patents can restrict the free flow of information and knowledge, hindering educational and research activities. Thirdly, the monopolies. So strong intellectual property can lead to monopolistic practices, reducing competition and leading to higher prices for consumers. And balancing intellectual properties rights and public interest. So achieving a balance between protecting intellectual property rights and serving the public interest is really critical. Policymakers need to ensure that intellectual property laws do not stifle innovation, restrict any sort of access to essential goods, or hinder this dissemination of knowledge. Mechanisms like compulsory licensing, fair use provisions, and public domain are vital in maintaining this balance. Case studies on intellectual property and public interest. So these are some examples. So number one, you've got the pharmaceutical patents and access to medicines, and that's the HIV/AIDS crisis in Africa highlighted the need for affordable generic drugs, leading to discussions on compulsory licensing. Number two, educational materials. So open educational resources, OER, as a response to the high cost of textbooks and educational content. Number three, software patents. So the debate over software patents and their impact on innovation and competition in the tech industry. Relevant case study images on news headlines. So number one, reforming patent laws, encouraging flexibility in patent laws to promote access to essential medicines and technologies. Number two, promoting open access, so supporting initiatives for open access to scientific research and educational resources. And number three, balancing interests, so developing policies that balance the needs of intellectual property holders with broad public interest, fostering both any sort of innovation or accessibility. In conclusion, while intellectual property rights are crucial for encouraging any sort of innovation and protecting creators, it's essential to critically assess their impact on the public interests. Policies and mechanisms must be put in place to ensure intellectual property laws do not hinder access to essential goods, education, and knowledge. So it's really important that we take into account when looking at intellectual property, why it's so important that it protects public interests. You know, it needs to protect any form of public interest because, you know, it ensures any sort of protection, avoids any sort of breaking of the laws being broken, but also it's reflected on the impact of everyone's daily lives. You know, everyone, you know, every day we come into contact with products and that are protected by intellectual property, and it rewards innovators for turning ideas from a cup of coffee, a better cup of coffee, to a more efficient car like electric cars, into technologies and sustaining our world. So as societies changes, it's used in everyday life. So we need to make sure that, you know, it does not hinder any sort of essential goods, education or knowledge. These are the references used for assessment criteria 1.4. Now we're moving on to 1.5, which is to analyse issues related to the breach of confidential information in intellectual property. Why is confidentiality so important in intellectual property? In general terms, intellectual property rights infringement is any breach of intellectual property rights. Intellectual rights are infringed when a work protected by intellectual property law is used, copied, or otherwise exploited without any proper permission from the person who owns those rights. So it's really important that, you know, people need to identify this. And some examples of intellectual property theft is things like electric vehicle manufacturers dispute over stolen trade secrets, a yacht company intellectual property sold by an insider via USB. So these are some examples of you know, intellectual property theft and why it's breached as well, why it's so important. So confidential information, often considered is a type of intellectual property, includes business secrets, proprietary knowledge, and other non-public information that gives a business a competitive edge. Protecting this information is crucial, you know, for any sort of organization. So types of confidential information: trade secrets, formulas, practices, processes, designs, instruments, patterns or compilations of information that are not generally known. Proprietary information owned by a company, including business plans, customer lists, and market strategies. Technical information includes data research and product designs that are critical to the company's operation. Legal framework for protected confidential information, such as trade secret protection laws in the UK are the UK Trade Secrets Enforcement Regulations 2018, non-disclosure agreements, NDAs, contracts that bind parties to confidentiality obligations, employment contracts, clauses in the employment contract that prohibit employees from disclosing any sort of information. For example, someone working for Coca-Cola would not disclose the ingredients in regards to that or the formula. Common issues in breach of confidential information, employee breach, leaving a company and sharing a proprietary information with competitors. Things like, an example would be things like KFC, you know, where they'd go out and share the recipe. Cyber security threats, hacking and data breaches that expose confidential business information, and third-party risks where vendors or partners mishandling or leaking sensitive information. Case studies on breach of confidential information. Waymo and Uber in 2017 were a high-profile case where an ex-employee of Waymo allegedly stole trade secrets and shared them with Uber. Another popular one was Apple and Samsung. In 2011, Apple filed a lawsuit against Samsung for infringing on multiple patents related to Apple iPhone and iPad product design, launching an ongoing series of cases between the tech giants. Apple claimed that Samsung had replicated the look and the feel of its device, including user interface and icons. Apple was awarded for this just over 1 billion in damages from Samsung, so it was a big amount. Another one is Morgan Stanley data breach in 2016, which was an internal breach where an employee stole confidential data affecting thousands of clients, you know, and in regards to that, it was identified that they'd been awarded compensation. Another historical example was Thomas Edison's phonograph, where Thomas Edison filed his first official patent for the phonograph. Frenchman Charles Cros initially invented it. Cros contested Edison's patent but failed, resulting in Edison making millions from his invention. Another example is the Wright brothers and the airplane. So this one, the path to success for Wright brothers was not smoothly flying, as several competing airplane inventors like Samuel Langley and Glenn Curtiss aimed to roll out similar airplanes. Patents were issued on behalf of the Wright brothers. It enabled them to prevent others from building similar planes, giving the brothers a monopoly on airplane reproduction for several years. Common causes and culprits of intellectual property, as we mentioned, it could be insiders, it could be hackers, it could be competitors, it could be threat actors, rogue employees. You know, it's really important. You know, insider threats are costly to any sort of organization. You know, it could be a high risk to the organization. As we mentioned, cybersecurity, it could be financial losses. So the consequences of breach of confidential information, and it's got there. Firstly, financial losses could be the theft of loss of intellectual property can result in significant financial loss for companies. This includes lost revenue, decreased market share, increased expenses relating to litigation, security measures, or damage control. One of the most prominent cases was the China's theft of the wind turbine company's intellectual property, resulting in a 1.2 billion case. The next one is reputational damage. So insider threats can also result in reputational damages for companies. If a brand is perceived as not taking adequate measures to protect its intellectual property, it may lose the trust of its customers, investors, and stakeholders. For example, a good one was a Facebook, which stock dropped by 7%. It valued at 43 billion loss after the catastrophic data breach incident involving Cambridge Analytica. And then legal penalties, you could have fines, sanctions, or compensatory damages ordered by courts. Remedial costs, it could incur additional costs out of cost. Litigation includes like legal funding, hiring experts to investigate the breach, or integrating better security systems. Any sort of, for instance, in a multi-million-dollar IP theft case, the company attack spent 14 million on alone on public relations, technical investigations, attorney fees, and litigation. So it's really, really important how to kind of prevent any sort of intellectual property and mitigate damages. Some preventative practice could be things like maintaining limited access controls, so ensuring that only authorized personnel can access any sort of confidential information. Perform intellectual property audits. Register your intellectual property as well, securing any sort of network or devices, any cybersecurity to protect your network. Monitor your competitors, enforce your rights, and ensure that you on current latest trends. So make sure the laws are in place, make sure there's protection, security, in place for individuals to, look at things like that. Also train employers on importance of protecting intellectual properties and how to identify common threats, particularly around intellectual property theft. In conclusion to 1.5, assessment criteria, breaches of confidential information pose significant risks for businesses. As we mentioned, it could be things like financial loss, your reputation. It could be things like, your legal consequences as well. A robust framework for protecting confidential information, including legal, technical, and organizational measures, is essential. It is so important for any organization to protect its own trademarks or its intellectual property, because there's so much going on and the world is changing. It's complex intellectual property, and more assets are being digitized online and accessible online. And there is intellectual property theft still remains a constant threat, whether in a digital or physical form. So it's really important, that you cover your intellectual property, and because of the changes in society, it changes all the time, so you need to be on the ball with technological changes. Any sort of, if there's any sort of hackers in place, your digital technologies are all in place and all up to date and protection with the law. These are the references used for assessment criteria 5, in regards to learning outcome 1. So a lot of the references are very similar to learning assessment criteria 1.1, 1.2, 1.3, 1.4, and 1.5. And we've some plenary, further reading, and ebooks and journals on Moodle for this unit. So make sure you've got further reading on Moodle. Go on to Moodle. There's additional resources there that you could rely on to look at learning outcome 1. Any queries or questions you've got in regards to this unit, industrial and intellectual property, email learnerwork@ukvarsity.co.uk. Again, submission of your assignment to be done on learnerwork@ukvarsity.co.uk, and we'll go through more of that when it comes to your assignment discussion, so you've got more of an idea how to do things, how to structure things, and how to make sure that you have completed the assignment in regards to the learning outcome and the requirements as well. Assignment submission is after 2 weeks of completion of the unit and its delivery. So once you've completed all the learning outcomes and done the assignment discussion, you're able to work on the assignment and complete within 2 weeks. A lot more will be done in regards to assignment discussion, so don't worry about that. That will come further down. The next session, we finished learning outcome 1 now. The next session is learning outcome 2, and I will see you there. Thank you for attending today's session. Thank you.